Study summary points 13. Fair housing applied. The application of the Civil Rights Act. Civil rights laws that affect real estate dates back to 1866 when the Civil Rights Act of 1866 was passed. The act makes it illegal to discriminate in the sale or leasing of real estate, housing, based on race and without exception. Jones versus Mayer. The Supreme Court upheld the case Jones versus Mayer and said that the Civil Rights Act of 1866 made discrimination based on race unlawful. This is true whether within the public or private housing domain. Title 8 of the Civil Rights Act of 1968 is referred to as the Fair Housing Act, as it expanded the 1964 Civil Rights Act to prohibit discrimination in the sale, rental, and financing of housing based on race, religion, national origin, and since the 1974 amendment, gender, and since the 1988 amendment, the Act protects people with disabilities and families with children. Familial status. Protection from discrimination based on familial status means that one or more individuals who have not attained the age of 18 years living together cannot be discriminated against, and this protection extends to someone who is pregnant or in the process of getting custody. Handicap status. Protection from discrimination based on handicap status means that anyone with a physical or mental impairment which substantially limits one or more major life activities cannot be discriminated against, including persons recovering from alcoholism and drug addiction. Discriminatory advertising. As clarified by the U.S. Department of Housing and Urban Development, it is unlawful to make, print, or publish any statement about the sale or rental of a dwelling that indicates a preference, limitation, or discrimination based on race, color, religion, gender, disability, familial status, or national origin. So even if someone appears to be exempt from the law, they cannot discriminate in the advertising. Steering. It is unlawful to steer a group of people away or towards housing based on being a member of a protected class. Blockbusting. Convincing owners to sell property cheaply by telling them that the property will lose value due to members of a protected group moving into the neighborhood. That's the definition of blockbusting. Redlining is when lenders and insurance companies deny services based on an area being made up of a high concentration of a protected group. Housing for older persons. The Fair Housing Act was amended by defining housing for older persons as being exempt from the law for housing intended for and operated for occupancy by persons 55 years of age or older. And because of the amendment, it is legal for communities to market themselves as 55 plus or age restricted. For the exemption to apply, they must maintain that 80% of the occupied units are occupied by at least one person who is 55 years of age or older. By letting the number fall below 80%, they could lose the status as an age-restricted community. Florida's fair housing law protects the same 7 classes as the federal fair housing law. The Fair Housing Act parallels the Federal Fair Housing Act. Florida laws do not add any additional covered groups or classes of people. Reasonable accommodations. The ADA requires reasonable accommodations as necessary to suit the needs of the person with disability. This includes changes in rules, policies, practices, or services to accommodate the person. Reasonable accommodations may be necessary in the housing itself or in the process of providing housing, such as how an application is taken or rent is collected. Reasonable modifications. Federal law requires that reasonable modifications must be allowed to alter housing to suit a person with a disability. This applies to private as well as public housing. However, these modifications are to be made at the resident's expense. Examples of reasonable modifications would include installing an entrance ramp, lowering the entry threshold, or installing grab bars in a bathroom. Multifamily housing. The law further requires that covered multifamily housing built and ready for occupancy after March of 1991 must follow design requirements to ensure that the housing is accessible to persons with disabilities. There are limited exceptions for owner-occupied buildings with no more than 4 units, single-family housing sold or rented without the use of a broker, and housing operated by organizations and private clubs that limit occupancy to members. Florida Residential Landlord and Tenant Act. Regardless of whether a rental property is being managed by a real estate brokerage property manager or the owner handling the property him or herself, there are landlord and tenant laws that must be followed per Florida Statutes, Chapter 83, Part 2. Access to the property for the landlord. Tenants cannot withhold permission for a landlord to enter the premises without cause. Tenants must allow landlords to enter the property to make inspections, provide services, make repairs, and to show property. The landlord may enter property at any time in case of an emergency. Otherwise, they are obligated to give tenants reasonable notice of at least 12 hours. A notice to cancel the lease. Either party must give notice to the other to cancel the lease. How much notice must be given depends upon how long the lease is for. For example, a yearly lease requires a notice of no less than 60 days, whereas a quarterly lease requires a notice of no less than 30 days, and a monthly lease requires no less than 15 days, and a weekly lease requires no less than 7 days notice. Eviction. To evict a tenant for non-payment of rent, a 3 business day notice must be given. After time is up, the landlord may file a complaint for eviction with the court. The tenant has 5 business days to respond to the complaint. If the tenant continues to occupy without responding, the landlord must obtain a final judgment from the court, and with the final judgment, post a 24-hour notice of eviction at the property. And the last step is that the court would issue a writ of possession, which is served by the sheriff to the tenant. Broker property management. If a broker manages rental property, the following rules apply. Deposits and advance rents must be deposited into the broker's escrow account. The broker may only keep $5,000 of the broker's funds in the escrow account to maintain the account. Sales associates must deliver rent and rental deposits to the broker by the end of the next business day. Advance rent and deposits are funds held in trust on behalf of the landlord and or tenant. They absolutely must not be used for anything else, even temporarily.